Mr. Shank, did Gail Wright really tell you that?
Yes.
Justice Alito said he didn't tell her. She said she didn't tell him, but you're sure she told you?
Absolutely.
Now, you wrote a book a couple years ago, is that right? 2018, you wrote,
yes.
Wrote a book?
Yes.
I want to read a section from that book. It's a section where you relate you and your family attended oral arguments at the court. You were there in the courtroom, and that directly involved your brother Paul, also a reverend. And I just want to read this section. You said, with the single rap of the gavel, Chief Justice William Rehnquist announced, "We'll hear argument first this morning in number 95-1065, Reverend Paul Shank and Dwight Saunders versus Pro-Choice Network of Western New York." Paul and I winked at each other, knowing we had made history with that reverend in his name. It had been a minor victory when we persuaded the court that reverend should remain before Paul's name, even though we had been told repeatedly that legal briefs never included such titles. You thought it was important that, obviously based on what you said, you thought it was important that the title reverend be in front of Paul's name, is that right?
Correct.
And why was that?
Because we saw it as a religious liberty matter, and that would make it clear that it fit in that category.
Did Chief Justice Rehnquist really say that, the way I just read it from your book?
I can't say that I remember that.
Well, you're pretty darn specific here. You got the number, case number 95-1065. Very next word says Reverend Paul Shank. You made it a big deal. Thought it's the first time it's ever happened. I'm just asking, did it really happen?
I wish I could tell. I would have to go back and review that.
So it may not have?
Possibly not.
Why do you say possibly not? You were emphatic in your book.
I would have to go back.
Well, we did go back. We did go back, and I got the transcript right here. Proceedings, 10:05 a.m., Chief Justice Rehnquist. We'll hear argument first this morning in number 95-1065, Paul Shank and Dwight Saunders versus Pro-Choice Network of Western New York. Did you hear it?
I did.
Was there a word missing?
Title Reverend.
Yeah, wasn't in there. In your book, you said it was a big deal, so much so that you winked at your brother. Did you wink at your brother?
Yes.
What'd you wink for if it wasn't in the title?
Well, it was our case.
But that's not, you said you winked because they included Reverend in the title, and the transcript says Mr. Rehnquist didn't.
Perhaps not.
Perhaps? Court reporter get it wrong? Did he say it? The court reporter get it wrong?
Well, then.
Well, we got the audio too. I'm going to play that for everyone to hear.
We'll hear argument first this morning, number 95-1065, Paul Shank and Dwight Saunders versus Pro-Choice Network of Western New York.
Reverend, did you hear that?
I did.
Was there a word missing that's different from what you put in your book?
A title, yes.
What was that title?
Reverend.
Reverend was not there. Right? Did you wink at your brother?
I think I did. In fact, I think I actually hooked him.
So now you got more details. You got the key detail wrong, what you were writing about in your book, but now you remember an additional detail. You not only winked, you elbowed your brother. Even though the reason for the wink in your writing was the fact that Reverend was using the title, something that had never been done, but it wasn't used. But we're supposed to believe you today. We're supposed to take your word over Justice Alito's word. We're supposed to take your word over a lady who gave you dollars donated to your cause, Miss Gail Wright. You're disparaging her name, Justice Alito's name, and the court. And you have this, which obviously didn't happen. We got the transcript, we got the audio, but you made it a big deal in your book. One thing I've learned, people who mislead folks on small things, mislead them on big things. And you know what? You can lie in a book, it's not a crime. You can lie to the New York Times, that's not a crime. But when you come in front of Congress and you say things that are not true, you're not allowed to do that. You're not supposed to do that. And we have seen it. You're not supposed to do that.
Is rhetoric on social media a problem and a threat to our democracy, Mr. Ward?
Yes, absolutely.
Mr. Siegel?
Yes.
Ms. Caraballo?
Yes.
Ms. Nomani?
Yes.
Ms. Tyler?
Yes.
Another question I have, do you believe that rhetoric targeting officials with violence for carrying out their constitutional duties is a threat to democracy? Mr. Ward? Mr. Siegel?
Yes.
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 All right, thank you very much. Only a few weeks after the attempted attack on a Supreme Court justice on June 25th, one of the witnesses, Alejandra Caraballo, tweeted out the following in response to a decision on abortion overturning Roe v. Wade, and I'll quote directly from the tweet: "The 6 justices who overturned Roe should never know peace again. It is our civic duty to accost them every time they're in public. They are pariahs. Since women don't have their rights, these justices should never have a peaceful moment in public again." I know something about being accosted. The night of January 5th, I was physically accosted on the streets of DC in Navy Yard by a constituent of mine. I fervently blamed rhetoric on social media, rhetoric at public events, for being physically accosted. I carry a gun everywhere I go when I am in my district and I'm at home, because I know personally that rhetoric has consequences. I've had my car keyed. I've had my house spray painted. I had someone trespass in my house as recently as August. I've been doxxed on social media about where I live. And I've had to add to security everywhere I go. Often, because I can't afford it, I have to carry my own firearm wherever I go. And Alejandra Caraballo also recently tweeted on November 19th, not even a month ago, that the Supreme Court, vested with the judicial power of the United States by our Constitution, stated they are not a legitimate court issuing decisions. And also the Supreme Court is an organ of the far right. So my last question today of Ms. Caraballo: do you stand by these comments, this kind of rhetoric on social media? And do you believe it's a threat to democracy?
Thank you, Representative, for the opportunity to clarify and provide context to my tweets.
I have a question, is it yes or no? Do you believe your rhetoric is a threat to democracy when you're calling to accost a branch of government, the Supreme Court?
I don't believe that's a correct characterization
What
of
you
my
tweeted,
statements.
though. Did you not tweet that? That you thought that the Supreme Court justices should be accosted?
What I'm
you
saying
tweet
is
that,
that
yes or
that is
no?
not an
Did you tweet
accurate characterization of my statements.
On June 8th of this year, a man was arrested near Justice Brett Kavanaugh's home in Maryland. He told law enforcement officers he wanted to kill a Supreme Court justice. He was found with a knife, with a pistol, 2 magazines, ammunition, pepper spray, zip ties, a hammer, crowbar, and duct tape.
Ms. Caraballo, on page 12 and 13 of your written testimony, you painted concerned parents as having been infiltrated by white nationalists and far-right militia groups, which played a significant role in school board protests. This has not actually been my experience with concerned parents. In your testimony, you wrote that in Loudoun County, Virginia, unfounded rumors that spread in local parent groups on Facebook about an alleged trans student sexually assaulting a girl in a bathroom led to a firestorm of several heated school board protests that descended into violence. But in fact, the perpetrator, it actually turned out, had committed 2 sexual assaults at 2 different Loudoun County schools in 2021 and was arrested on October 7th, 2021 by the Loudoun County Sheriff's Office. These weren't unfounded rumors, as you suggest. It actually turns out law enforcement had to act because a sexual assault occurred. So giving this, I'm assuming that until now you were unaware of what happened here, and you're going to update your testimony for the committee. Is that correct?
So I'd ask if you would just answer my question directly. This isn't a question, Judge Gray, I may vote for you anyway, but I'll commit right now in front of God and country to vote for you if you'll move back to Louisiana. Judge Lynn, I've read a number of your writings. I want to, you wrote an article in December of 1998 entitled Person of Faith, Race and Religion as Experiential Knowledge. You wrote it in a a journal called Perspective. And this is what you said, I quote, your words, not mine. The problem with the Christian Coalition is not that they are Bible thumpers, parentheses, there are personal beliefs that often result from religious experiences, close parentheses, but that they are bigots, end of quote. Did I quote that correctly?
I believe you did.
Did you write that?
I did write that when I was 18 years old, or 20 years old, excuse me. I do want to be clear. I do not agree with that today. I wrote that before I went to law school, before I had any kind of
You were a grown woman when you wrote this.
I'm sorry.
You were a grown woman when you wrote this.
I was 20 years old when I wrote it. It was before I had a professional career.
You were in your third year at Harvard?
I was
A senior at Harvard.
I was a junior at Harvard.
Junior. So you were 3/4 of the way through your Harvard education, and you wrote that.
That is correct, Senator. It is
Wow.
20 years before I became a judge. I do
Wow.
not agree with it today. I do want to be clear about that.
Okay. Judge Simmons, let me just ask you a couple of questions. You finished law school in 2004?
Yes, sir.
All right. Have you ever tried a case in federal court?
I have not seen there.
Have you ever filed a brief in federal court?
I have not practiced in federal court. My entire practice has been in the state court.
Okay. Have you ever argued a motion in federal court?
I have my entire practice of over 12 years as a prosecutor has been in state court, Senator.
Okay. Have you ever, you serve as a state court judge, have you ever presided over a jury trial as a state court judge?
In the 5 years that I've been on the Superior Court bench, I have been in a moving department, and now I'm the supervising judge.
Have you ever tried a jury trial?
As a attorney, I have tried.
No, as a judge.
As a judge, I have presided over court trials, not jury trials, sir.
No, so the answer is no.
I have not presided over jury trials as a
Okay.
judge.
Have you, in the 5 years you've been on the state bench, have you ever written any opinions, issued any opinions?
Well, sir, I've been in moving departments in the 5 years that I've been as a Superior Court judge. We don't issue written opinions in moving departments on the
So
Superior
the
Court.
answer is no.
In the 5 years I've been on the Superior Court, I've been in moving departments. We don't issue written opinions in moving departments.
Okay. What is the standard of review in federal court for questions of fact?
For questions of fact by the trial court, it is clear error, sir.
Okay. What's the standard of review for questions of law?
In the trial court level, it's de novo.
Okay. What is what's the holding in Map v. Ohio?
In Map v. Ohio, since I've been practicing as a district attorney for the last 12 years, as well as a Superior Court judge over the last 5 years, I know what the holding is. It escapes me as I currently sit here, but
Okay.
as a Superior...
What's the Chevron doctrine? You'll see that a lot.
Yes, Chevron deference refers to an administrative agency that's interpreting its own rule. It created a two-part step test. The first step in that test is whether Congress was clear.
You know it. I got you. What's the political question doctrine?
I have not, as a Superior Court judge, and over the last 5 years, and as a Deputy District Attorney for 12 years, I have not practiced in a federal court, so if I am so fortunate enough to be confirmed, I will obviously apply the applicable law.
Okay, I want to talk about the United States Constitution. Is it a doctrine of plenary powers or enumerated powers?
Enumerated powers, sir.
Okay. I yield back 1 second, Madam Chair.
Thank you, Senator Booker. Senator Kennedy?
Thank you, Mr. Chairman. Judge, congratulations.
Thank you.
I want to try to understand the facts on some of these cases.
Yes, sir.
The Albertus Lewis case. He shot his girlfriend in the head. Is that correct?
Senator, as I stated, I'm not sure if you were in here earlier, that case is still pending. He's not been convicted of any of those charges. And so I have to be really careful in how I frame my question.
Did he shoot his girlfriend in the head?
Senator, based on, those are the allegations of the charge, yes.
So you're saying he didn't shoot his Girlfriend in the head?
He has not been convicted of anything, is my understanding. And I know it's a very old case. It's 2017.
Well, when you
but
granted him bond, did you think he had shot his girlfriend in the head? He was charged with shooting his girlfriend in the head, wasn't he?
Thank you, Senator.
welcome.
Those are the allegations. When he initially appeared before me,
Okay.
I denied his bond based on everything.
Let me
that was
start
before
over, okay? Mr. Lewis was charged and arrested, so presumably there was probable cause, with shooting his girlfriend in the head and putting her body in a wheelchair and dumping her outside the hospital. Those were the allegations. Is that right?
I believe those were the allegations, yes, sir.
Okay. And you gave Mr. Lewis bond. Is that right?
No, that's incorrect, Senator. I denied his bond. When he appeared before me in July of 2017.
So you didn't give him bond? He didn't release him?
I denied his bond. It was 2 years
Did you
later.
ultimately release him?
2 years later, after the state violated the
Did you
court's
grant
order.
his bond? I'm just trying to understand the facts.
Yes, sir. 2 years later, after
You
the
granted
state.
his bond.
When he initially appeared before me, I denied the bond. It was 2 years after
Okay.
that I granted a bond.
You did grant the bond.
After the violation by the
Right.
state of the court order to try his case and discovery rules.
And then he went out and tried to kill 2 sheriff's deputies while using a baby as a human shield, allegedly. Is that right?
Those are the allegations in the other case, yes.
Okay. Would he been able to do that if you hadn't let him go?
Thank you, Senator.
You're welcome.
When he appeared before me, I denied his bond. He appeared before me again, at which point
And you let him go?
the state violated the order of the court.
But I'm just
And I
trying to
set a
understand the facts.
sufficiently
You
high
let him
bond.
go. If you hadn't have let him go, then he could not have tried to kill 2 sheriff's deputies using a baby, a child, as a human shield. Factually, is that correct?
I'm not sure, Senator.
Oh, I think you are. Let me ask you about Kelly Honeywell. You remember that name?
Senator, I did not have any involvement in that actual case, but I am familiar with what you're referring to.
Okay. Do you remember Troy Stevenson?
Yes.
All right. Troy Stevenson was arrested, allegedly, for shooting Kelly Honeywell, killing her, murdering her at a bakery. Mr. Honeywell was arrested. And Mr. Honeywell allegedly was a member of a gang. He owned guns and he did drugs. Okay? You granted Mr. Stevenson bail. Is that right?
In that case, I did not set bail bond in that case when he was charged with murder.
You didn't let him go?
I did not set the bond on the murder charge.
Who did?
I don't know who's, one
Then
of
how
my
did he
colleagues.
get out of jail?
Are you asking about the murder charge?
What I'm asking, and I think you know what I'm asking, Mr. Stevenson allegedly was arrested for shooting this bakery worker in the head, and he was granted bail. He was let out. You didn't grant the bail?
No, sir.
Who did?
My understanding is his bond was denied in that case on the murder case. Mr. Stevenson, I believe, after trial, was found not guilty of those charges. But I did not set the bond on the murder case. I did not try the case on the murder case. I did not set the bond on the murder case.
Okay. I think I'm out of time. Thanks, Judge.
All right, thank you.
If you enjoyed this video, hit like and subscribe to our channel so you'll be sure to see similar videos from BlazeTV with the added bonus of signaling YouTube that your voice and opinion still matters. And if you're looking for more great conservative content, check out one of the 2 videos suggested here.